Are you recording?
Yo.
I'm not exactly sure
We're going to have to talk kind of loud, though.
where it should start at. But today we're going to be looking at Chapter 12 of the Corrections, a critical approach to corrections. And in Chapter 12, we're going to look at prisoner rights. And specifically, we're going to go into detail on the major developments in the history of prisoner rights, and that includes hands-off policy, the rational basis test, total of conditions, deliberate indifference, restrained hands, and the Prisoners Litigation Reform Act of 1996, and the importance of the writ of habeas corpus. That is just one section of the chapter that we're going to look at. We're also going to go, well, let's just dive into that part. Now, the introduction of the chapter, historical development of prisoner rights, writ of habeas corpus, legal services in prison. Well, dating back to ancient Rome, a common form of punishment was to strip convicted criminals of their citizenship and formally pronounce them slaves. By virtue of losing their liberty, the offenders were then subject to spend their lives in penal slavery. In legal terms, the punishment was known as civil death. Consequently, the felon's property was confiscated and his wife was declared a widow, becoming eligible to remarry. As previously mentioned, slavery represents an intersection of politics and economics. Slaves do not have legal rights, nor are they allowed to benefit financially from their labor. The parallel between slavery and punishment in America persists decades after the Emancipation Proclamation. One of the first landmark decisions addressing prisoners, Ruffin v. Commonwealth, 1871, the court ruled that convicted felons not only had to forfeit their liberty, but for the length of their sentence also were slaves of the state. Ruffin, as a consequence of his crime, not only forfeited his liberty, but all his personal rights except those the law and its humanity accords to him. In the decision, the court ruled that Ruffin is I hate these Latin words in this book. Civiliter mortis, and his status, if he has any, is administered like that of a dead man. The court went on to state that the Bill of Rights applies only to free men, not convicted felons, and men civilly dead who have forfeited their constitutional protection. The impact of this decision was felt for the next 90 years, during which time the courts were unwilling to consider the complaints of inmates, including those concerning the general conditions of their incarceration. Constitutional deprivation and the abuse of the institutional authority. In sum, the Ruffin case referred as the legal justification for the courts to maintain a hands-off doctrine. And that is the first part that we need to cover, the hands-off policy. As a result, corrections officials were permitted to operate prisons and jails free from constraints, even if physical abuse of inmates was employed to instill discipline and horrific living conditions persisted in the prison. So basically what that says is that the hands-off policy is the policy that basically rips all felons of their constitutional protection. Which time the courts were unwilling to consider, and they didn't consider any complaints of the inmates, including those concerning the general conditions of their incarceration. As a result, In 1960s, however, the court began to retreat from the hands-off doctrine, and change precipitated by the civil rights movement. Indeed, is that what I have to do? Rational basis does. Indeed, many veteran civil rights lawyers were instrumental in shaping the prisoners' rights movement. As a result, the corporation of a few sympathetic judges, several successful legal challenges against correctional systems were made. Still, the prisoners' rights movement did not produce results overnight. Actually, several years passed before inmates benefited from any of the key legal decisions. For example, Monroe v. Papp resurrected the Civil Rights Act of 1871. Civil Rights Act of 1871 allowed lawyers to file an action in federal court against state abuse of individuals. Resurrected the Civil Rights Act of 1871 and allowed lawyers to file an action in federal court against state abuse of an individual's rights without first executing state duty. What just beat that?
Nothing.
3 years later, the U.S. Supreme Court handed down a landmark decision in Cooper v. Patt that applied directly to prisoners. In fact, the importance of Cooper is that it overturned Ruffin, thereby formally recognizing that constitutional rights of prisoners, specifically prisoners in state and local institutions, were now entitled to the protections of the Civil Rights Act of 1871. So, Cooper basically made it so it took out Ruffin. Ruffin said that cases served as legal justification for courts to maintain a hands-off doctrine. So what was the Civil Rights Movement of 1871? Resurrected the Civil Rights Act of 1871 allowed lawyers to parallels between the Civil Rights Movement and the Prisoner Rights Movement were made more than symbolic. As correctional populations became increasingly African American and Hispanic in the 1960s and 1970s, the Prisoner Rights Movement was viewed as a civil rights movement behind bars. That's probably a good thing to note. Prisoners' rights cases were based on the constitutional safeguards pertaining to due process, cruel and unusual punishment, censorship, free communication and access to the courts, and religious and racial discrimination. Restrained hands, he didn't cover that part. Writ of habeas corpus, the most fundamental legal relief available to all persons confined in federal or state correctional institution is the writ of habeas corpus. From the Latin, you should have the body. Guaranteed by Article 1, Section 9 of the United States Constitution, the writ of habeas corpus allows individuals to seek relief by challenging the lawfulness of their confinement. To highlight that. We know what the writ of habeas corpus is, but it's good to have that exact wording. Makes you sound smart when you go. In Article 1, Section 9 of the United States Constitution, the writ of habeas corpus allows individuals to seek the relief challenging the lawfulness of their confinement. You know, like a lawyer. Originally, the rationale behind the writ of habeas corpus was to permit individuals to contest the legality of their confinement. But in 1944, It's Cooper. Coffin versus Richard. The Sixth Circuit U.S. Court of Appeals ruled that prisoners could challenge the conditions of their confinement by way of the writ of habeas corpus. So at first, writ of habeas corpus was only to challenge the legality of their confinement. And in 1944, Coffin versus Richard, you could now challenge the conditions. In the Coffin case, the conditions of the confinement extended to the physical abuse of prisoners. Sometimes when I feel like I'm talking like this, you remember in Peanuts, the cartoon with Charlie Brown, confinement by way of writ of habeas corpus. You know how the teacher lady, in their class, is just like, just kind of feel like I sound like it. Oh, so the hands-off policy is an example of hands-off doctrine. Basically says the impact of the decision forfeit their constitutional rights. Not constitutional protection, but in Cooper versus Pat in 1964, which I should highlight as well, he appealed the decision of prisoners. In fact, the importance of Cooper is that it overturned the hands-off doctrine, thereby formally recognizing the constitutional rights of prisoners. So the hands-off policy is that they have no rights, basically. The sliver. That's a big old monkey. Sometimes I forget that we're recording stuff. Oh my goodness. Almost got it. Take a break from studying real quick and get rid of this liver guy. I don't know if I can get it.
I got a hook. Oh, a plaque hook, like those dental hooks. If you need it. That I haven't used on my teeth yet. Ew. I can go get it for you.
I need something like a card, like a driver's license or something.
Here.
Preferably.
See if that works.
Oh, there we go. Got it. And that, boys and girls, is how you take care of a sliver. So, as guaranteed by the 14th Amendment, having complete and unobstructed access to the courts was often easier said than done. Many state correctional institutions imposed regulations that required inmates to submit all legal documents to correctional administrators before they were to be filed with the courts. The rationale behind the regulation was to enable correctional officials to censor the prisoner's documents, thereby interfering with the inmate's access to the courts. The problem was partially addressed in Ex Parte Hull, in which the Supreme Court stated that prisoners' rights to apply to a federal court with writ of habeas corpus was not be impaired by the state or its officers. It was the business of the courts, not correctional officers, to determine the merit of their petition. Legal service in prison. Inmates can... I feel like this is about to be super long and boring. It's pretty dry, man.
Not for me.
Not fun stuff. Despite the Hall rule, inmates continue to struggle with their right to have unobstructed access to the courts. Prisoners who filed suits often faced formal, official, and informal, unofficial punishments. In many instances, prisoners were subject to disciplinary action for filing suits. That's bullshit. And COs often hassled litigois inmates? I don't know what that is. Stealing documents from their cells and otherwise interfering with their legal activities. Eventually, the courts acknowledged that correctional officials often interfered with the inmates' access to the courts, either by deliberately sabotaging the prisoners' legal attempts or by denying the prisoners the basic materials and resources required to complete a legal document, such as a law library. It should be noted that some correctional systems forbid a practice of jailhouse lawyering, whereby knowledgeable inmates assist others in the preparation of a writ of habeas corpus and other formal legal relief, which I need to know. Jailhouse lawyering is where other inmates assist with the legal preparation of a writ of habeas corpus and other forms of legal relief. In Tennessee, jailhouse lawyering was banned whether or not a fee was involved. A prisoner there named Johnson, who had spent nearly 1 year in solitary confinement for repeated violations of the ban of jailhouse lawyering, filed a suit against the state. Do I need to know about Johnson versus Avery? No, I do not. Well, in Johnson v. Avery of 1969, the U.S. Supreme Court ruled that because many inmates are indigent or illiterate or lack the knowledge about their constitutional rights, that they may rely on the assistance of others, unless the institution offers a better alternative to legal assistance. I feel like I should have to know that, but I don't. Subsequently, other key decisions addressed the problem of prisoners not having adequate access to the courts. Correctional institutions are now required to establish an adequate law library. And that was a part of Younger v. Gilmore in 1971, or legal service program, to permit inmates to rely on jailhouse lawyers and filing civil rights actions against prison staff or administrators. So, basically, jailhouse lawyering is when other inmates assist in the preparation of legal documents. It was banned, and in Johnson v. Avery, the U.S. Supreme Court ruled because many inmates are unknowledgeable or can't read or write, that they have to have them rely on the assistance of others. So the question was, what are jailhouse lawyers? What are their roles in inmate litigations? They basically helped prepare documents for other inmates who weren't knowledgeable about what they should do. Just as a citizen turns to the courts to settle their disputes, so do prisoners. For convicts, however, the opportunity to have the court hear their grievances is still a relatively recent phenomenon. Over the past 40 years, prisoners have been able to seek relief in their courts primarily because the judiciary has become willing to process such cases. In the past 5 decades, an onslaught of suits has been tremendous, although the heavy volume of inmate suits might seem to indicate a victory for rights of prisoners. An exceedingly high dismissal rate must also be considered. Prisoner lawsuits have the worst success rate of any type of any type of civil suit filed in federal court. Because nobody cares about prisoners because they're in prison. But I bet you they get messed with a lot. What has been the impact of prisoner rights movement on corrections and the criminal justice process? Inmate litigation often incites indignant reactions among citizens who believe that convicts should have only limited access to the court. Got a picture message. Picture of Ollie wearing April's sweater. Awesome. Wow, I've been talking for 23 minutes and 12 seconds. Pretty interesting. What is this on my shoulder? You see this? You see it? You see where I'm pointing on the screen right here?
It's probably just the shadows.
I don't know. Anywho, back to the bullshit. Oh, the viewpoint has generated several misconceptions concerning prisoner litigation. A false perception exists that inmates habitually abuse their constitutionally guaranteed right to the access of courts. Due to that misconception, the wave of inmate suits begins in the 1960s and erroneously interpreted as legal pollution and a national disease. Legal scholars also caution that characterizing prisoner litigations as unfair bombardment of the legal system is misleading. Before the 1960s, there was virtually no prisoner cases processed by the courts. So, as the hands-off doctrine was dismantled, it appeared as if they may deluge or explosion of inmate suits. So, what does that mean? A false perception of fiction. Another misconception suggests that inmates only file frivolous suits lacking legal or substantive merit. Some prisoners have filed frivolous cases, for example, In one case, a convicted complained about the commissary deodorant, and in another, a prisoner filed a petition citing cold toilet seats and a need for television antennas. I want a cold toilet seat. In 1992, that was when I was born, a prisoner filed a civil rights suit demanding $1 million for cruel and unusual punishment suffered when a CO refused to refrigerate his ice cream snack, leaving it to melt. I'd want $1 million if somebody refused to refrigerate my ice cream snack. In other cases, a prisoner filed an injunction to save prison officials from reading his thoughts. These cases, like all other frivolous suits, were dismissed. Critics of the inmate litigation insist that even frivolous suits take their toll on the courts, since the suits still must be filed and reviewed. Advocates of prisoner litigation, however, argue that the burden caused by inmate suits is exaggerated and that the system needs not to be modified. Indeed, the courts have formally addressed the problem of frivolous cases filed by inmates, and in In Re Green, 1981, the courts cited a prisoner who in 1970 had filed as many as 700 suits on behalf of himself and fellow inmates. The courts characterized Green's suits as frivolous, irresponsible, and lacking legal merit. Still, such frivolous cases are atypical of prisoner litigations. But when frivolous cases do surface, very often they are subjected to intense media scrutiny, dramatization, and sensationalism. As a result, prisoner litigation is often mocked or inaccurately portrayed as imposing an unfair burden on the legal system. As is demonstrated throughout this chapter, the vast majority of inmate cases are based on serious, blatant violations of constitutional rights, including petitions citing barbaric living conditions, physical abuse, and assaults. I really should have been highlighting more stuff in here because I'm not writing any of this down, and I'm going to have to go back and do it later, and then I'm just going to have to read everything again. That's the nice part about highlighting stuff, is because then you can go back and be like, alright, let me look right here. So basically, inmate litigation is legal documents filed by inmates to the courts. Jailhouse lawyers help them do that. The jailhouse lawyer. Over the past 30 years, scholars have focused attention on inmates who engage in extensive litigation. Those who assume the role of a jailhouse lawyer. Jailhouse lawyers are simply prisoners who file a suit in court. Oh. Okay. I guess I was kind of wrong. Nearly all inmates at some point file a writ of habeas corpus, while many others seek alternative forms of legal relief during incarceration. Rather, jailhouse lawyers are prisoners who make a prison career out of law. Jailhouse lawyers go beyond using the law to resolve their own grievances. They also help other prisoners shape and translate their personal troubles and problems of prison life into a legal issue and claim. Let me highlight that bull. That bullish. Milovic and Thomas also note that jailhouse lawyers serve as gatekeepers, weeding out suits that lack legal merit. The most talented jailhouse lawyer attempted to link a particular issue that affects only a single inmate to one that ultimately affects broader prison policies. Jailhouse lawyers are permitted to help prisoners file legal documents when no other legal assistance is available. Thus, the institutions with limited availability of legal assistance, the presence of jailhouse lawyers is magnified.
Half hour.
Still haven't ran into rational basis test, total of conditions, deliberate interference, restrained hands. But we have not covered the Prisoner Litigation Act. Oh, there it is! The Prisoner Litigation Reform Act of 1996.
Would you like to learn about it?
Among the major recent developments in inmate litigation is the enactment of the Prisoner Litigation Reform Act. The legislation was driven in large part by public and political perception that inmates' litigations was out of control and frivolous lawsuits were clogging the courts. Moreover, the PLRA, don't know what that is, Prisoner Litigation Reform Act, represents a shift toward victims' rights and social movement that purported that prisoners had more rights than victims. Ooh. The PLRA set out to reduce the number of civil rights suits by limiting what the courts can do in prison cases and imposing sanctions for filing frivolous cases. I guess that makes sense. What I don't understand is they're making this big fuss about frivolous cases filed by prisoners, but I guarantee you there's just as many frivolous cases filed by normal people. That statute was further bolstered by Title I of the Anti-Terrorism and Effective Death Penalty Act, also passed in 1996. The AEDPA sought to regulate the filing of habeas corpus petitions, especially in death penalty cases. Despite its popularity, some lawmakers were concerned that the PLRA has been rushed into law without carefully considering that it may undermine prisoner rights. Alright. Senator Edward Kennedy complained that the PLRA was the subject of a single hearing in Judiciary Committee, hardly the type of thorough review that measures of this scope deserve. Critics argue that the time when lawmakers were looking for ways to make prisons tougher, the PLRA served to keep poor conditions and other grievances from public scrutiny. Well, that's kind of stupid.
$35 minutes.
Oh, excuse me, 34 minutes and 30 seconds. Let us continue. Essentially, the PLRA makes it far more difficult to use litigations as a means of correcting defective prison conditions. In effect, the courts have moved from a hands-off to active intervention in management of prisons. Is that something I have to know? No. Well, I still should have to like it. So, what was the Prison Litigation Reform Act? Legislation was driven in a large part by public and political perception that inmate litigation was out of control and frivolous. Board. Reform in the Texas Department of Corrections. I just want to know what all this bullish is about.
I'll tell you what it's about. It's about a dummy.
Major developments in inmate litigation. Although few institutional reform cases are as sweeping as those of Texas. Do I need to know about Texas and Arkansas? I probably should. Ugh. Yeah, I look funny when I yawn. Anywho. By the late 1990s, 35 states, along with the District of Columbia, Puerto Rico, and the Virgin Islands, were under court order or consent decree to either limit correctional crowding or improve conditions of their confinement. Regardless of the volume of suits, not all cases filed by prisoners resulted in institutional changes. Very often, the courts side with the administration of the facility regarding certain policies and practices. As discussed in Chapter 11, a significant class action suit of Bell v. Wolfish addressed the rights of pretrial detainees. In particular, inmates challenged the practice of double bunking in overcrowded Metropolitan Correctional Center, a federal jail in New York City. I knew about that. The suit also alleged violations of constitutional rights such as undue length of confinement, improper searches, inadequate employment, recreational and educational opportunities. The U.S. Supreme Court rejected the argument that such conditions violated inmates' constitutional rights. More importantly, because nearly all pretrial detainees were released within 60 days, double bunking was not regarded as unconstitutional. It has been suggested that the Bell-Wolfish signaled a return to the hands-off approach by the court. 2 years later, In another stupid case that I don't need to know about, apparently, Rhodes versus Chapman, the U.S. Supreme Court upheld that the double bunking practice in the Southern Ohio Correctional Facility in Luxonville, citing that totality of conditions test. I need to know about that. Total of conditions. Citing the totality of conditions test, the High Court ruled that double bunking in and of itself is neither cruel or unusual punishment. The decision also cautioned federal district courts to stop acting as administrators and give corrections officials the broad discretion they need to operate their institutions. Rational basis test? Right? Let's see that. Also, in the 1980s, additional restrictions were placed on the constitutional rights of prisoners. For instance, Hudson vs. Palmer, another stupid case that I don't need to know about. Russell Palmer argued that correctional officers unreasonably searched his cell. In that case, the U.S. Supreme Court ruled that Palmer, a prisoner, was not entitled to the same degree of Fourth Amendment protection. Well, obviously, people can have a shiv. Go out shanking somebody. No, the major constitutional rights exercised by prisoners with respect to the First, Fourth, 8th, and 14th Amendments. So they basically don't have a Fourth Amendment. I.e., privacy and protection against unreasonable search as citizens in the community. The court went on to explain that incarceration requires that the rights of inmates be restricted to ensure the safety and security of the institution. It is under the restriction of those rights that the institution must continue to enforce its enforcement against contraband, i.e., drugs and weapons. Makes sense. Oh, it says something about the 8th Amendment. Prisoners in the 1990s have found it difficult to fight against conditions considered cruel and unusual because the U.S. Supreme Court decided in another stupid case I don't need to know about, well, I probably do, decided in Wilson v. Cedar that inmates have to prove that prison officials acted with deliberate indifference. I need to know about that. Deliberate indifference to basic human needs. That ruling significantly curtails the 8th Amendment protections for prisoners because that ruling significantly curtails, I don't know what that word is, 8th Amendment protections for prisoners because proving that prison officials acted with deliberate indifference to basic human rights is often difficult. So, deliberate indifference is they basically don't care. It's like me saying, no, you're not allowed to take a poop right now. I don't want you to. You will not take a poop right now. You can poop your pants, but you're not going to the toilet. And that is hard to prove. Anywho, sentencing laws designed to control habitual offenders have been in existence since the 1920s. More recently, their popularity re-emerged in 1990s under the rubric 3 strikes and you're out, requiring judges to sentence repeat offenders with 3 convictions to longer prison terms. The rationale of 3-strike laws rests on the basic assumption of deterrence. If the cost of the behavior greatly exceeds its benefits, the behavior is less likely to be chosen. If the behavior continues in spite of the cost must be increased. That makes sense. I don't think I need to know about this, though. So, I don't care. Restrained hands, total conditions, we've gone over that, gone over that, gone over that. Rational basis test, we have not gone over that. Ooh, the First Amendment to the Constitution. Following a period of considerable progress toward inmates' rights, the courts have struck a balance between prisoner rights and the need for correctional institutions to maintain internal safety and order. Although the judicial trend over the past several decades might be viewed as favoring prison officials, the courts sometimes have not only recognized prisoner rights, but fervently defended them as well. In this section, the landmark decision affecting inmates' rights, specifically those pertaining to the constitutional rights, are presented. Generally, prison litigation involving constitutional rights often focus on the First, Fourth, Eighth, and 14th Amendment. I'll highlight that because I need to know about the First, Fourth, and 18th Amendment. Congress shall make no law, so the First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press, or the right of the people peaceable to assemble and to petition the government for redress and grievance. God, I hate the wording of the Constitution. It's so stupid. Cases filed by inmates to challenge institutional policies and practices related to the First Amendment rights typically fall into 4 areas: religious freedom, freedom of speech, censorship of personal correspondence, and the right to assemble. So I need to know that. This is just one chapter too, isn't that stupid? Oh, religious freedom basically says what it is. Freedom of speech, you know about that. Censorship of personal correspondence, 2 landmark cases of see, there's stupid cases in here that I probably need to know about. Wolfwood versus Clemmer. Nope. I'll just go back over that later. The Fourth Amendment to the Constitution, the right of the people to be secure in their persons, house, papers, and effects against unreasonable search and seizure shall not be violated, and no warrants shall issue but upon probable cause supported by oath of affirmation and particularly describing the place to be searched and the person or things to be seized. Obviously, prisoners don't have that right because they're in freaking prison. Since prison and jails place a security and safety as the highest priority, the courts have consistently ruled that prisoners are not guaranteed the same protection against unreasonable searches that extend to other citizens. Indeed, such searches are necessary to confiscate weapons and other contraband and more versed people. The U.S. Supreme Court upheld the practice of random searches, shakedowns, and seizures in prisons, noting, however, that such searches were not to be used as harness or humiliate the inmates. Later cases, Belvers. Ooh, do I need to know that? No, we already went for Belvish, Holvish, or whatever. Fourth Amendment cases nonetheless become more controversial when searches involve visitors and staff. Visitors are often subjected to pat-downs upon entering the prison in an effort to detect contraband. Subjecting visitors to strip searches or bender spreads invites questions of concerning the Fourth Amendment protection. Prisoner officials are generally permitted to conduct a strip search on a visitor as long as they have reasonable suspicion. Still, what constitutes reasonable suspicion is not always clear. Since the courts have resorted to loose standard and reasonable suspicion, the prisoner administrators are granted a greater discretion. It's such a touchy topic, though. I mean, I wouldn't want to go into prison to go visit my mom or something and have to take my clothes off and put my ass against my feet and cough. The Eighth Amendment. Excessive bail should not be required, nor excessive fines imposed, nor cruel and unusual punishment. We call the importance of Roos versus Stowe and Holt versus Saber. In both cases, the U.S. Supreme Court ruled that conditions in confinement were so barbaric that they violated the Eighth Amendment ban on cruel and unusual punishment. In fact, the court went so far as to declare that Texas and Arkansas prison systems unconstitutional, so that their mere sentencing and of an offender to these institutions constituted cruel and unusual punishment. In Chapter 10 of the Eighth Amendment, the death penalty is discussed in depth. Since the Eighth Amendment's ban on cruel and unusual punishment reaches beyond the capital punishment to include other penalties imposed in correctional institution in this section. Okay, so it protects against physical abuse, deadly force, solitary confinement, medical treatment services. The 14th Amendment. Woo! All persons born and naturalized in the United States and subject to the jurisdiction therefore are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law that shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. So, the significance of the Fourth Amendment as it applies to prisoners is that it imposes due process in the Bill of Rights on states, hence the notion of equal protection. Further, the 14th Amendment pertains to prisoners' rights by encompassing both legal service to inmates and due process rights in disciplinary hearings. That makes sense. That way people can't just be like, oh, you pissed me off, so I'm going to throw you in the hole. Since an earlier section addressed legal service in prison, the segment deals with issues related to procedural due process. In the landmark case of World... Oh, I need to know about that one! The U.S. Supreme Court found that the state of Nebraska has proceeded to improperly in revoking an inmate's good time, a reward for good behavior, and reduces prison sentences. I'm so happy the semester's almost done. The High Court upheld that the prisoner's claim that his good time was revoked unfairly because his due process rights were violated in his disciplinary hearing. So, seeing that he had, although the court concurred that an inmate facing disciplinary charges is not entitled to the same due process as defendants in a trial, the court did establish minimum requirements for disciplinary proceedings. For example, a prisoner must receive advance written notice of an alleged violation, and he or she must have sufficient time to prepare a defense. Again, makes sense. I can't believe you're recording this. For prisoners, the Wolf ruling provided a greater contribution to the protection of due process rights than an earlier decision relating to disciplinary hearings. And the Lamb v. Payton, that we know about, impact of the prisoner rights movement. What was the impact of the prisoner rights movement? I didn't know about word. Among the more systematic examinations of prisoner rights movement in the delivered movement is that delivered by sociologist James Jacobs. In his assessment, the prisoner rights movement over the past several decades has had a significant impact on the correctional administration and management. That is, correctional institutions have been forced to rely less on coercive mechanisms to control inmates and to resort to a more bureaucratic measure instead. Prisoner litigations have increased operational standards for correctional institutions, thereby promoting them to function more bureaucratically than in the past. Today, prison officials must formally respond to grievances and lawsuits by producing their own reports concerning the alleged violation. See, I feel like I get into sometimes where I'm just like a highlight crazy guy. Additionally, prisoners in jails have become increasingly bureaucratic owing to the establishment of due process safeguards, which enhance the formality of disciplinary hearings and other procedures. Understandably, some correctional officers feel alienated due to their perception that the courts are on the side of the convicts. So, correctional officers don't like this. In response, correctional officers have formed unions, thereby generating an adversarial relationship with correctional administrations. Are you going to stop it?
Mm-hmm.
You got to at least let me reach an hour. We got like 10 seconds before I'm at an hour. Another consequence of prisoner
Well, here
rights.
it comes.
Oh goodness. 3, 2, 1.